Alright, they're recording. Alright, everyone's ready. The head director standing.
Of course.
Sorry.
Could you please introduce yourself to the members of the jury?
Hello, my name is Hayden Durant.
Could you tell us a little bit about your family?
Yes, I have one daughter and her name's Jessie. She's 15 years old.
What do you do for a living?
Well, I'm actually an accountant at Rock World Amusement Park. I had to take over a couple years back after the last accountant quit because of a robbery.
Now, Mr. Duran, if you work at Rocker World, does that mean you live here in Midlands?
Yes, indeed, I live at 25 Maple Street.
Could you tell us where the Park family lived prior to August 18th, 2010?
Yes, the Park lived at 23 Maple Street. We were actually next door neighbors.
Did the Parks have any children Jesse's age?
Yes, the Park had a daughter named Sydney. She was only 11 back in 2010.
Were Sydney and Jesse close growing up?
Oh yes, they were very close. I had to work late a lot at Rocker World, so Jesse would go over to Sydney's house, and the Parks would watch them together. They were always playing, even on the weekends.
I understand that they spent a lot of time at the Parks place, but did you ever watch the kids, Mr. Duran?
Yes, absolutely. On the weekends, they would come over to my place. The Parks and I always wanted to help each other out with watching the children.
In your time watching the kids, did you ever hear them get into any arguments?
No. The extent of their arguments would be what they would watch on TV that night or what they would eat for dinner, but that's about it.
Did you ever see them get into any physical altercations or fights?
No, absolutely not. No fight.
Did you ever hear Jesse threaten Sydney?
No fight.
No. You said that they spent some time at the Parks place. Were you ever notified by the Parks or their babysitter about any arguments the kids might have had?
No, I was not.
Were you ever told of any threats?
No.
Any fights?
No fights either.
At any point in which you lived next door to the Parks, did you get the impression that Jesse was unwanted at their home?
No. If anything, it was the exact opposite.
Objection is to speculation, Your Honor. Response.
Your Honor, if I may make an offer of proof outside the ears of the jury.
We're constructively outside.
He's about to go into an instance in which the Parks helped them hold a game of fence in their yard. This goes to his rationally based perception. He's not speculating as to their mindset, he's just making his opinion based on something the Parks did. So, Mr. Duran, I'm going to re-ask that question. At any point, did you get the impression that Jesse wasn't wanted at the Parks home?
Not at all. It was the exact opposite, because the Parks actually helped me one weekend build a door in between the fence and our backyard so the children could go back and forth as they chose to.
Mr. Duran, at any point at which you watched the kids, did you ever see them hurt each other on purpose?
Absolutely not, no.
Objection, Your Honor, is speculation. May I be heard on that? Sure. Mr. Puglici just asked the defendant if he ever observed one or the other children hit each other on purpose. The intention of those actions is he's speculating into the intention of those actions.
First, Your Honor, the witness responded that there was no such action to which to imply for consent, so there is no speculation in that respect. But secondly, if there was, it would go to the rational based perception of someone walking with the fence, being able to perceive them as they occur. Mr. Duran, at any point did those children hurt each other on purpose?
No, they did not.
Did you ever see them hurt each other, even as a kid?
No, they were playing tag together and one would fall down, the other would help him right back up. That's just the type of friends they were.
Well, Mr. Duran, I'd like to talk to you about August 18th, 2000. Could you tell the members of the jury what your work schedule was?
I had to leave for work around 9 a.m. that morning, so I woke up a bit before that and I started getting ready.
What were you going to do with Jesse while you were at work?
Well, I was bringing Jesse over to the Parks house. They had agreed that they would be able to watch Jesse that day.
You said they agreed. Did they agree that day or sometime before?
No, yes, it was a week in advance. This was very routine for us. Whenever I got my work schedule for the week, I would speak to Andy, and she would agree that she could watch Jesse on the days I could.
Who usually watched the kids while they spent their time at the Parks house?
Well, Lee was usually at work before I did, so it was always either Andy Park or Danny Brooks. the babysitter.
Mr. Duran, on August 18th, 2010, who was watching those children?
No one was watching them on August 18th.
Mr. Duran, were those kids ever left alone before?
No, absolutely not. They were only 11 at the time.
Did the parks give you any advance notice that they wouldn't be able to babysit Jessie?
No, I walked Jessie over that morning. Just minutes before I had to leave for work, Andy Park told me that the babysitter couldn't make it that day.
How long were the kids left alone?
They weren't left alone for more than an hour.
How was that? What happened?
Well, I sat down at my desk at work, and I had my coffee, and I got a phone call from Jessie.
Was that usual?
No. As soon as I saw Jessie's name, I felt like something was wrong because I had never gotten a call from Jessie while I was at work.
Did you pick it up?
Yes. I picked it up, and Jessie said that I needed to come home immediately because something had happened.
Did you rush home, Mr. Duran?
Well, yes, I ran down to my car, and I sped home as quickly as I possibly could.
When you got back to your front lawn, what did you see?
There were police cars on the lawn, ambulance, paramedics. There were people in uniforms everywhere, but I couldn't find Jessie or Sydney.
Did you try to go inside the park's home to see if Sydney and Jessie were there?
Yes, as soon as I got out of my car, I ran up to the door, and I stopped for a moment because I felt like what I was about to see was not going to be good.
Mr. Duran, did you take that step into the parks?
Yes, I did. I thought I saw Jessie lying under a bloody white sheet.
Was it Jessie, Mr. Duran?
No, it froze there screaming for I don't know how long. And then an officer grabbed me by my arm and brought me into the dining room. And that's when I saw Jessie sitting at the dining room table, okay.
Mr. Duran, if Jessie was sitting unharmed at the dining room table, then who was under that sheet?
It was Sydney's part. And when I say I felt better after seeing Jessie okay, Jessie and Sydney were like sisters. Sydney was like a daughter to me. Still felt just as terrible knowing that it was Sydney.
Mr. Duran, did you try and console your daughter that day?
Yes. I couldn't imagine what she was feeling like, so I ran up to her and tried to hug her and tell her everything would be okay, but I couldn't.
Why not?
Because an officer grabbed me and sat me down and said that I couldn't touch Jessie, and that if I wanted to talk to her, it would have to be in the presence of all the officers.
Mr. Duran, on August 18th, 2010, did you ever get a moment alone with your daughter?
No. We were kept in that dining room surrounded by those officers for I don't know how many hours, and then we were stuffed into the back of a police boat.
Thank you, Mr. Duran. I have nothing further.
Yes, Sean, before I begin, may I retrieve a few documents? My name is Emma Allen. I just need to ask you a few questions about what happened to the August 18th. So, right? Now, your daughter was your only child, right?
Jessie.
Just you two and your family.
Yes, it was Jessie, I, and our corgi Amanda.
And two of you against the world.
Yes, I guess you could say that.
Two of your own family. Now, you weren't around that much.
Well, I was around on the weekends. Yes, I was a big part of Jessie's life. While I was at work, she would have to go to the park.
That's right. You worked a lot there.
Yes, that is correct. The park was open later.
And felt guilty.
I mean, I love Jessie. I wanted to spend all the time with her that I could, but I had to pay the bills.
So that's the best. You feel guilty about not spending much time with your daughter.
Yes, that's it.
So, it's good.
You know, I mean, I would offer what I could. I wanted to make sure she was happy, yes.
You talk about some of the things you bought her because you felt guilty. You bought her a dog because you felt guilty.
Yes, it was our Corgi name.
You bought her video game system because you felt guilty.
Yes, I bought her video game system, but I didn't buy her all this stuff just because I felt guilty.
Now, do you remember, is it your testimony you did that you buy these things because you felt guilty?
I mean, my guilt may have played a role in it, but it's also just because I wanted my daughter to be happy.
Now, I want to make sure I heard you right, Mr. Grant. Did you or did you not buy your daughter all of these things because you felt guilty because you weren't there?
Yes, you could say that.
Now, because you weren't able to be home that much, the parks watched your daughter a lot during the week.
Yes, that is correct. On the days that I had to work late.
They were on call if you needed them.
Yes, just as I was for them on the weekends.
Now, Mr. Duran, during that time, when your daughter was spending so much time at the park, she could probably some problems in school.
She did have some problems in school, that's right.
Now, I want to talk a little bit about that. Did you recognize a notice of your daughter's discipline already showed you?
Yes.
Fortunately, to meet you, this was already been remanded as kind of a deal. May I approach you, Mr. Duran? Mr. Duran, that's a notice of student discipline that your daughter received.
Yes, it is.
That is actually the third incident where your daughter was in trouble.
Yes, that's what it says here.
Third incident where your daughter was in trouble for being molested. I'm going to talk about each of those. The first time your daughter hit one of her classmates,
Yes.
you didn't do anything about it.
No, she came home that day crying hysterically. I didn't punish her for that, no.
So you're telling us that your daughter hit another student and you didn't punish her.
Yes, that's right. The whole rest of that night, she was talking about how bad she felt for it.
So that's never been done.
No, I did not.
Now, the second time that your daughter got in trouble for attacking another student, you didn't do anything.
It was that same case. It was the same child that had been bullying her throughout the year. And again, she came home and she felt bad, but it was another instance where she did step back.
So, the second time that your daughter attacked one of her classmates, you still didn't punish her.
Yes, that was the second, didn't I?
Now, the third time that your daughter attacked other students, took away her video.
Yes, of course. The third time I felt that it was time to punish her, and I did take away those video games from her.
And that was on just the word of the week.
Well, yes, but she doesn't play her video games every day. These were very important to her. I felt that this would be the most effective punishment. And she did not get in trouble at school again, so it was effective.
Now, Mr. Duran, you also found a comic in your daughter's room.
Yes, that's correct.
You recognize it?
Of course.
Turning to Mitsubishi with the evidence that you say is dead. May I purchase the room? Now, Mr. Duran, that's a piece of artwork that you found in your daughter's room.
Yes, it is.
And in that drawing, she includes pointing a gun at other kids.
Yes, she stated that it was a Nerf gun that she was pointing at. That's correct.
Now, Mr. Duran, is it your testimony that it says on that it's a Nerf gun?
Oh, no, it doesn't say that on here. It just says my gun.
So it's just a gun.
Yes, but they had played with Nerf guns all the time, and this is what she said when she spoke about it.
Now, do you remember making a statement that you spoke to your daughter about that cartoon?
Oh, no, I did not include that in the statement. No, I did not think that would be relevant.
Now, this is a little confused. You didn't think it was relevant to include in your sworn statement that you spoke to your daughter about a cartoon where she's pointing guns at other kids.
Well, I didn't think it would be assumed that this was a real gun my daughter was pointing at other children. She was very young at the time. I did not assume that this would be a real gun. I didn't think it would clarify.
Well, Mr. Green, you never spoke to your daughter about that gun, did you?
No, but she did.
You didn't speak to your daughter about that gun.
At the time I received this, I was under the impression that it was a Nerf gun.
But you didn't play.
That's correct.
You
Yes, that's absolutely correct.
And you didn't punish her for that.
No, it's definitely not. It was artwork, as you would say.
Now, you also wrote an email to a friend of yours, Stephen.
Yes, I did. As usual.
And you recognize that?
I would.
Sir, Mr. Kukulichi, what's remarked is Exhibit 8 for identification. May I approach Dr. Mr. Duran with Exhibit 8? Now, Mr. Duran, you wrote this email.
Yes, I did.
You remember writing every word in it.
Yes, I do.
And looking over it, it's a fair and accurate copy of what you wrote.
Absolutely.
You're on a plane of news for remarks of Exhibit 8 to evidence. Any objection?
No objection, no.
Submitted. Now, in this email, you talk about how worried you are about your daughter's behavior.
Yes, I was worried that Jesse was only playing video games instead of doing other things.
You were worried that your daughter would like games.
Yes, she was just playing one game for a while, that's correct.
You were worried because you could hear your daughter screaming, "Bang your dad."
No, this was on a different occasion. It wasn't related to the video game.
But you were worried about that too.
Well, yes, I was just worried about Jesse overall.
You said you were worried about your daughter overall.
Yes.
You know, Mr. Duran, let's talk about all of those things. All of the problems that your daughter has been having at school. You never told Andrea and me to talk about them.
No, I did not. I didn't think that would be necessary.
You didn't know your daughter spent lots of time with you.
Well, yes, but her and Sydney were best friends. I didn't think she would attack Sydney. At school she was getting bullied, but Sydney and her got along very well.
Now, that drawing where your daughter depicts pointing guns at other kids, you didn't tell the parts about that.
Oh, no, they spent a lot of time with Jesse. I assume they knew Jesse had an interest in guns in the military as well.
I'm assuming.
Well, yes, they spent a lot of time with Jesse, as we had said.
Now, and all of these concerns that you talk about in this email, with the video games, with the guns, with the yelling,
I did not tell the park about the video games Jesse was playing, no.
Now, I want to talk a little bit about a conversation you had with your daughter on August 17th, 2000. Now, that day you found out your daughter was aware there was a gun in the park.
Yes, that's correct.
You knew your daughter wanted to play with it.
Yes, I knew she wanted to see and feel it, yes.
Not just see and feel it, she wanted to play with it.
Yes.
And you sat down and talked about that. You don't know exactly what you were.
Objection, Your Honor. Speculation.
Your Honor, this is just a rationally based perception of the witness. I never thought for our court where I was a youth jury. I expect that Mr. Duran will testify that he spoke about the park's gun to his daughter, and she responded, "Yeah, but I want to play."
Yes.
Now, when you talk to your daughter about that gun, your daughter confirms that she wanted to play.
No, that's not correct.
She said she wanted to touch it.
Yeah, she said she wanted to see and feel it. Yeah, she said she wanted to see and feel a real gun, though, not the park's gun in specific.
Well, she said she wanted to feel that.
She said she wanted to feel a real gun. And I told her that guns are very dangerous and not to be played with. We've had this conversation before.
Well, when you said that, you actually don't think your daughter understood you.
I mean, I did not think my daughter would harm anyone.
That wasn't what I asked you, Mr. Duran. I asked you if you didn't think your daughter understood talking about gun safety.
No, I couldn't be sure.
She just
Yes, that's correct.
The very next day, you dropped your daughter off at the park.
Yes, I did.
You knew that your daughter and Sydney would be alone in that house.
Yes, that's correct. There was told me before I had to leave her. Because of the break-in that happened earlier in the year as well, yes. Very awkward situation for me having to leave Jesse alone at 11. Not because of that late. Yes, I wasn't comfortable.
So that the yes might,
Yes.
you were uncomfortable.
Yes, I was.
And didn't say anything.
No, I didn't have to leave the door.
You didn't say, hey Andy, my kid wants to play with your gun.
No, I did not.
You didn't say, hey Andy, my kid knows you want to.
Objection, Your Honor, after an answer to order.
Yeah, no, Danny Brooks spoke to me the night before that and told me Jesse wanted to play with the gun. So, I mean, thought Danny would have spoken to Andy as well.
So you assumed again.
Well, yes.
And you left your daughter with the gun in your shoulder.
I did leave my daughter alone.
And we freely published any redraft.
No redirect, Your Honor. I draft on Mr. Bruno be excused.
Any other witnesses? Can you please introduce yourself to the court?
Good evening. I'm Dr. Ash DeRosa.
Dr. Rosa, where did you attend school?
I got my master's in public health from Tufts University and my doctorate in health policy and management from Midland State University.
And after obtaining your doctorate, where did you go?
I began my career as a research associate at Tufts University, focusing on gun storage and gun-related injuries.
What do you do now?
Well, I now teach at Midland, where I'm a tenured professor teaching public policy and management.
Do you do any activities related to your job?
In 2002, I joined the board at a Midland Center for Responsible Gun Policy and Legislation, where we often give presentations on different types of safes and gun storage, ranging all the way from lunch boxes, Gucci safes, all the way to reach trucks.
Have you published before?
I've published in over 30 scientific and peer-reviewed journals, yes.
And have you acted as an expert witness before the case?
Yes, and in 15 civil cases.
Dr. DeRosa, do you know Hayden Duran?
Yes, in September of 2011, Mr. Duran asked me to determine whether or not the parts safely stored and maintained the weapon that they owned and kept in their house.
And do you know, or did you end up conducting this investigation?
Yes, I did.
What information was provided with in order to conduct your investigation of that call?
I was provided with the reports of Jules Sebastian, along with names of Andy Price, Danny Brooks, and Hayden Duran.
Was it enough for you?
Yes, ma'am, this was enough.
And when conducting these types of investigations, do you implement reliable nuclear methods?
Yes, oftentimes when determining whether or not a safe is safe, we use the safe method. It's a little ironic, but it really is the best way to determine whether or not a gun is stored safely. The safe method stands for storage, accessibility, fail-safe, and effectiveness.
Did you use the safe method in the investigation of current products?
Yes, I do.
With the research that you do, have you found that it's dangerous or detrimental for one to use a firearm?
Perhaps, but not necessarily. Guns in the home can be a good safety measure if the safe storage method is followed, but they are associated with an increase in risk of homicide and suicide by family members and friends.
Have you found that homes that contain guns have an increased risk of misfiring a weapon?
Sadly, yes. Recent studies have shown that for over half of those who have owned a weapon for over a year have accidentally fired it on at least one occasion.
Can you explain to us why the risk of experienced gun owners misfiring a weapon is so high?
Of course, there are many ways an accidental firing can occur. One way is the person holding the gun will have their finger on the trigger without the intent to fire, and they'll pull the trigger for a demonstration, not realizing that the gun has been left loaded, thus causing the gun to discharge. Other times the person will be holding the gun, again with the finger on the trigger despite the intent to fire, and they may fall or stumble, compressing the trigger on the way down, thus causing the gun to discharge.
Is the risk of misfiring a weapon increased with the hands of an inexperienced gun owner?
Unfortunately, yes. The risk skyrockets when the gun holder is inexperienced. People such as children who have never held or fired a weapon before face a dramatic increase in the risk that an accidental firing will occur.
Do you know how old Dr. Durant was on August 18th, 2020?
Jessie Durant was 11 at the time, putting her in the group most likely to be harmed by keeping guns in the home.
Have you found evidence to suggest that Jessie Durant had come in contact with or fired a weapon prior to August 18th, 2020?
No, I did not.
And are there ways to mitigate the risk of children coming in contact with them?
Of course there are, and that's exactly what the safe method is all about. A gun must be stored unloaded and locked away in a safe, with the bullets stored separately in response to accessibility concerns. This acts as a failsafe and effectively decreases the risk that an accidental firing will occur.
And Dr. Urza, I want to direct your attention to the investigation based on time. You use safe method in your research. Can you tell me how you implement the safe method in your investigation?
Just like I actually bought a graph with me that I bring to all the courts, all the trials I testify at, just to explain actually what the safe method is.
Your Honor, may the witness testify.
Yes.
This is safe method. The first part of your safe method is storage. Can you tell me where does the parts store their guns?
The parts store their gun in a Gallucci safe, which is ideal considering that Gallucci safes make some of the best safes in America.
Is there anything wrong with the parts storage system?
No, the safe was a great condition, so there was no problem with the storage itself.
There's no problem with the storage. Can you tell me what you look at in terms of accessibility?
In terms of accessibility, I can look at two factors. One being the physical location of the safe, the second factor being the overall strength or weakness of the combination to the safe.
So in terms of location, can you tell me where the parts store their safe?
The parts store their safe in their bedroom, which is not ideal considering that their bedroom door had no lock on it, making it accessible to others at all times.
Moving on to combination, can you tell me where do the parts store their combination?
The park stored their combination on a piece of paper in an unlocked filing cabinet in an unlocked guest room. An unlocked filing cabinet that both Sydney and Jesse had easy access to at all times.
Dr. Rosa, can you tell me, was there anything about the combination that was not effective?
A common mistake people use in choosing the combination is they'll choose very easy to guess combinations, such as their birthdays or anniversaries, which offer little protection. Unfortunately, the park fell victim to this, as a combination was made up of Andy, Lee, and Sydney Park's birthdays, and a safe is only as safe as this combination.
Did you find that the park storage system was fail-safe?
In order for a storage system to be fail-safe, that means that the bullets must be stored separately from the gun, and unfortunately, the parks did not do that.
Dr. Rosa, did you find that the park storage system was effective?
Based on the accessibility of the safe, as well as the accessibility of the combination, and the overall weakness of the combination, I determined that the safe was not effective. Therefore, the park storage system was not safe.
Let me return. I have no further questions. How's it going?
Yes, Dr. Rosa, you were hired to evaluate how the parks work.
That's correct.
And this is the evaluation system you use.
Yes.
Let's talk about this a little more. Now, you mentioned again that you stored your gun in a delusion.
Correct. And that was very good. I give them credit on that because those mistakes are like magic. I mean, they just work wonders.
Again, you commend them, and so we can agree that they stored it.
Correct. In terms of the safe that they chose, yes.
Now here in accessibility, we talked about the location of the delusion safe.
Correct.
And you're aware that they stored it in their bedroom.
Correct.
But you also understand why they would want to do that.
I understand why they want to do it, but that doesn't make it the best idea. No.
Not ideal, but again, you say you stay down the record, and so much need to access it would be understandable if they would store the location.
Correct. And when you want to choose a location, you want to make sure that it's accessible to the gun owner, but not accessible to others that you don't want coming into contact with the gun. That can provide an even more dangerous situation.
You know where the gun owners or Lee or his wife on radar.
Yes, I agree.
And he stored it in there.
Correct, which was always unlocked.
But nonetheless, you can agree that it is understandable that they should want to have access, should they need it.
Yes, it is understandable.
So we're going to now we're going to talk about the combination. You again commend them for not telling their combination everything.
Correct, that was a good job on their behalf, yes.
You find them to fail safe. You talked about storing ammunition separately from the firearm.
Correct.
You stayed on the record they didn't do that.
Correct.
You don't know.
There's actually a discrepancy in the affidavits that I read about where the bullets were stored.
Exactly. Sandy Brooks, well, she stated that she didn't see where the bullets were.
Correct.
But the gun owner on Red Park told you the bullets were stored separately.
Correct, but what Celtic means is the accessibility to the bullets, and of course, Sydney and Jesse had accessibility to those bullets.
So without crossing off these streets, you can't stay with your store and continue.
Based on the fact that city sweet innocent like the lost their life, I would say so, yes.
The fact that you can't check off location, combination, or the sales page, you can't determine your store.
Correct, but as word shows up.
Individually, we agree on that.
Great, which unique most of the deeper aspects of it.
Dr. Rosa, when you were hired, you were hired as an academy, correct?
Correct.
To implement this system.
Correct.
And this is the only system that you can evaluate how to improve.
Correct, it was.
You never want to progress.
No, I was on the case a year later, and the parts had already moved at that time.
So you never got to see the bedroom where it was stored.
Unfortunately, no.
You never got to see the things in the property.
No, I did not.
And you never got to tell you it was fire.
No, I tried to, but I was not allowed to.
And in fact, you never even interviewed the gun in.
No, I did not find that necessary, given the information that was provided.
And you also didn't find it necessary to interview Andre Park.
No, I did not.
So in evaluating how their gun was stored, you didn't find it relevant to interview the people who stored the gun.
No, all the statements gave exactly what I needed.
Dr. Gertrude, when you were hired initially, you were hesitant to take a break.
Correct. I was a little more conflicted.
And the defendant approached you and tried to retain your services.
Correct.
You turned him down.
Correct. Like I said, I was more than conflicted, and at first I wasn't sure if I wanted to take vacation or not, because it was very hard for me to work.
But when he came to you again, he doubled your salary.
Correct.
And that's when you took it.
Correct. And at that time, I decided to put aside my feelings and decided to educate people on how the guns should be stored to make sure that the situation like this never happens again.
You decided to inside your feelings to send a message about how dangerous guns are.
Correct. Given the opportunity to potentially save lives, I took that opportunity.
Now, when you were being contacted by the defendant, he had to reach out to you, correct?
Correct.
And if I were to reach out to you, I could send you an email.
That's right.
I could email you at pagerosa@parentsagainstguns.com.
That's right, Counsel. You know that we've been in contact this whole time.
No, we've not. I appreciate that answer. Now, also, when you, again, were conducting your investigation, you never spoke to anyone.
No.
But you only spoke to the defendant.
Correct. The registrar said put me on the case.
You only spoke to the defendant in the office of Delaware County.
I spoke to him prior to that. He could have offered it to Delaware Street prior to that.
But aside from any interviews that you chose not to conduct, the only person you had contacted was the defendant.
Correct. He's the one who put me on the case.
And you chose to take it to the office of Delaware County.
Oh, I decided that I want to potentially save lives.
I sent you a message about how dangerous these things are.
That's correct.
Any reason?
Any other witnesses?
Constructively, we'll assume that Jesse's been called, after the first case. Never over across, but no action.
Alright, Jim Moran.
Who normally? Kristen Shaw.
She does.
Yeah, she can't do today.
There's a legitimate reason. She is a music major in her final exam.
Oh, I didn't know if she was done with.
No.
I was just checking. I didn't know if she was like.
We're not real show. Alright.
She's doing it.
Mr. Nicker, probably your name.
Hello, Jesse. My name is Justin Nicker, and I just have a few short questions for you. As soon as I'm done, we'll get you out of here as soon as possible. Now, Jesse, you enjoy playing video games, don't you? In fact, you like playing all types of video games. You like playing sports games, racing games, and shooting games. But even though you enjoy playing all of these different types of video games, the majority of games your father, Kate Duran, watched were shooting games, weren't they? But the majority of the games were shooting games. And Jesse, your father wouldn't just buy these shooting games for you, he would also play them with you, too. Now, on several occasions, you got into a little bit of trouble in school. In fact, on one of these occasions, you got into a fight with your fellow classmate over a game of dodgeball, correct? Because of this fight, a week, but that was still a suspension. Even though you got suspended, your father never punished you. Jesse, on August 17th, 2010, days before Sunday, you and your father, you had a conversation about the gun at your father's house. You told your father you was really shoot that gun. But nonetheless, you did tell your father that you really liked to see that gun. But you said you were really interested in seeing this gun because you had never seen a real gun before, had you? In fact, the only guns she had ever seen in her real entire life were in their shooting games. And just to clarify, these shooting games that got you so interested in guns, these were the ones that your father got you? Yeah, I have.
Finding the mistake of closings, that's great.
That was key.
Alright, we'll take a few minutes recess. Your Honor, I gotta pee.
You cannot take in any drink.
I need
It's just
meat
frozen.
I need
Yeah, it's
this,
been frozen
notice.
for a while.
Yeah,
You been putting
So,
no,
It's still running in the office. That's what the screen says.
No. Okay, awesome.
Me too, I'm so tired. Oh yeah. You work in law.
no, I work here. But so I like so you know I close and I usually stay afterwards and I looked up to right about 4:30. I looked up again like what about it was 5:05. And like I was like, oh sweet, I'm gonna be able to take care like all my time to go get ready and go to shower and everything. So like this is good. It was like I have no idea how that changed.
What was their the time change was like a week and a half ago. If you look at a clock, it wasn't changed.
No, I looked at
Oh yeah, I mean,
yeah, maybe. It was weird though. Very weird.
no need your opening.
Okay. I can try.
I haven't been scoring. I've just taken notes for roughly about not usually I'm taking critique notes for like if people taking notes. So I remember Emma's on these English movies, so you're gone.
E for Emma.
The person's like, why didn't you?
I will open.
Come watch my thing here. I do. Oh, that's right. You can be like with like at least one time, I guarantee you every single time. The competition, the film competition, 7 minutes long, and David Rand dominated. That all his team did was get home. So I entered that into evidence and then dropped it.
Wait, I don't know if you're gonna be a second part of
You would agree that.
So I'm technically gonna take
And then when they said it, the person that I did it to said, oh, I left my phone on in my pocket, but it's just a pistol.
But
And like, that was in the last round, and I was like, oh, yeah, I do that every time. I know, I heard it. Never done.
Everything that's active.
Never seen it ran on NBA.
yeah.
Oh, who don't know that?
Shake the tent.
I've only seen one video.
We've never seen it.
Actually, no, that's a lie.
Did it all of the risk factors associated?
Or I just started being in the middle and the eye.
Oh, yeah.
And the one round was my neighbor's car. And I crossed.
I've only crossed paid that. That's why I'm screwed out of that. Like I know hate.
I was just like,
No, I mean, you got it. I mean, he just, yeah. I actually wrote down, I was like, we don't get a beach on the kill sheet.
Alright, guys.
You know how to intimidate. You get that.
Members of the church. When a parent neglects their responsibility, then they're responsible for what happens. Now, growing up, I was often told that there's no such thing as a bad student. It's bad teachers. For quite some time after, the meaning of this quote is lost. But what it means, members of the church, is that to those who have the ability to shape a child's life, such as parents, also have the responsibility to teach that child the difference between what's right and what's wrong. It is their duty to punish a child's harmful behavior and to reward the good. And should these individuals choose to neglect their responsibility, well, then they're responsible for what happened. Now, the defendant, he had a responsibility to his daughter, Jessie Durant, to Sydney Parker, and to the entire Parker family. But he neglected. Hayden Durant chose to ignore the warning signs that his daughter had been exhibiting for years. Warning signs that could have saved Sydney's life. He was negligent as a parent, and as a result, he is responsible for what happened. What happened was that on August 18th, 2010, Jessie Durant shot and killed Sydney Parker. Now, at the beginning of this trial, my co-counsel, Grayson Wallace, she stood right here before you, and she told you that we proved by a majority of the evidence that the defendant, Mr. Hayden Durant, was negligent, and that his negligence was a direct and proximate cause of Sydney's death. And then, members of the jury, my co-counsel told you that we would prove this to you by a preponderance of the evidence. However, we are bringing forth a charge of negligent parental supervision. And in order to find the defendant liable for negligent parental supervision, we had to prove three things. First, that the defendant, Hayden Durant, knew of the risk that his daughter, Jessie Durant, posed to others, but that he chose to do nothing about it. Second, we need to show that the defendant failed to overlook his daughter's behavior, and as a result, and third, that on August 18, 2010, either Hayden or Jessie Duran acted recklessly, and as a result of his recklessness, so, this first aspect. So we had to prove to you that Hayden Duran knew of the risks of her daughter posed, and that she chose to do nothing about it. Members of the jury, you didn't have to look any further than the testimony of Dr. Campbell Solo, a child psychiatrist who specialized in chronically violent children in the town. She took that stand today, and she told you that after reviewing all the necessary evidence and after utilizing methods that have been both peer-reviewed and accepted within her community, she was able to conclude that Jessie Duran exhibited all of the risk factors necessary for her to classify Jessie as a chronically violent child. And then you heard Dr. Solo tell you that the defendant found chronically wrong by her daughter, his daughter, Jessie. This comic was titled Me in My Way. And in this comic is a strip that shows Jessie holding a pistol and pointing it at other children, with the caption reading, "This is me, and this is me," scaring all the bad kids away, proving that the defendant had knowledge of her daughter's violent fantasies, and that he knew of the risks that his daughter posed to others, but that he chose not to do anything about it. So what did he do with this information? Well, you could answer to that question. You have to pay attention to the testimony of none other than Mrs. Drake, Sydney's mother. She took that stand, and she told you that despite constantly relying on the courts to provide supervision for his daughter, the defendant never once mentioned Jessie's prior violent behavior. He failed his responsibility as a parent, and as a result, now, the second point that we had to show that the defendant failed to adequately overlook his daughter's behavior. Again, we need to look no further than the testimony of Ms. Hendrick. Because again, she took that stand and she told you that after taking away one of Jessie's most violent and bloody video games, she grew thick. And that when Mrs. Park was finally able to bring this behavior up with the defendant, he just blew it off and blamed on some problems that Jessie was having at school. What were these problems? Well, members of the jury, you heard from Jessie Durant herself, and she took that stand and she told you that she had not one, not two, but several violent instances at school. The most recent of which can be described as Jessie kicking and hitting other students, all the while screaming, "I killed you, and you need to die." Now, this third, we had to prove on August 18th that either Hayden or Jessie Durant acted recklessly, and as a result of this recklessness, didn't correct that. Again, you heard Jessie Durant herself. She took that stand and told you that she had been excited to play with the Parks gun for kids. And then on August 17th, 2010, Both Aiden and Jesse Duran had a conversation about the gun that was located in the Park home. And then you learn that even though the defendant was aware that his daughter knew of a gun in the Park home, that she wanted to touch it, hold it, to shoot it, he did nothing. He went along with business as usual and dropped his daughter off at the Park's home the very next day, forgetting to mention any word about it. Members of the jury, then you heard from investigator Sebastian. He took the stand. He told you that very same day, the defendant dropped off his daughter. City Park was shot. Now soon, Judge Posada will take you back into that deliberation room and she will instruct you as we as the plaintiff had the burden of proof against the case. She will tell you that we as the plaintiff had to prove all three of these elements by a preponderance of the evidence. And I realize that this legal term, preponderance of the evidence, may sound a bit confusing to some of you, but all it means is that after today's trial, if you still believe that all three of these things are more likely than not to be true, then you must find the defendant liable for negligent criminal supervision and for the death of the victim. No parent should be forced to bury their 11-year-old. There are memories that no parent should have to live. Now, Mr. Andrea Park will never be able to pick out prom dresses with her daughter. And Mr. Lee Park will never be able to walk Susan down the aisle because his future was stolen. So please, find me.
Yes, Your Honor. May it please the court, Mr. Nipper, members of the jury. The story that Mr. Nipper has just told us is a tragedy. And our hearts, they go out to Miss Park for her loss. On August 18th, 2010, a precious young girl was taken from us too soon. She'd be in high school, looking forward to college down the line and a bright future. Someone with a baby girl back home, I can't even imagine what these past few years have been. It's a fate that I would not wish on anyone. But what happened on August 18th, 2010 was an accident. And if anyone had seen it coming, then it would not have happened. You see, members of the jury, it can be scary to live in a world where someone as young as Sid can be taken in an instant. When a tragedy like this strikes, it's in our nature to try and find somebody to blame. Members of the jury, it's our job here today in court to fight that instinct. Because not every tragedy has a villain. Not every tragedy has someone to blame. And on August 18th, it was not the park's fault. But it wasn't Mr. Duran's either. The fact of the matter is that when it comes to something as important as keeping our children safe, we never really know whether it's safe enough until a tragedy like this strikes. And on August 18th, it was safe. But it wasn't safe enough. And when it isn't safe enough, and no one can see it coming, there can't be anyone to blame. The plaintiffs had the burden to prove to you each and every element of their claim by what's called a preponderance of the evidence. This means that each and every element on its own needed to be more likely than not. If any one of them was not, then you cannot find Mr. Duran liable. That's a burden that's rested at this table throughout today's trial. And it cannot shift over to the defense unless we choose to accept it. You see, we didn't need to call any witnesses to that stand. We didn't need to ask any questions, elicit any testimony, or present you with any evidence. But we did. And we took on a burden of our own because what the plaintiffs and Mr. Nipper have tried to prove to you today just did not happen. We tried to bring you a claim of negligent parental supervision. And let's dig deeper into what that really means, what you're going to have to decide when you go back to that deliberation. They had to prove to you by a preponderance of the evidence that Hayden knew or should have known the risks Jesse posed to Sydney Park, that Hayden ignored those risks, and it was Hayden ignoring those risks that caused Sydney Park's death. Key element here is causation. Throughout today's trial, they've given you all of these alternatives, all of these other explanations, things that Hayden could have done, but what they have failed to do is prove to you that more likely than not, any of those things would have prevented Sydney's death. They've tried to tell you how when a parent neglects responsibility, they need to be the ones to accept the consequences, but members of the jury, this disciplinary note that they're basing this case on, the disciplinary note you're going to have and see, you heard what Hayden did. Hayden punished his daughter. And after punishing his daughter, she never misbehaved again. Members of the jury, he did what a responsible parent should do. He took the necessary steps, and he saw results. They can't prove that what Hayden did caused siblings. Because of him, they failed. We, on the other hand, have taken a burden of our own to prove to you an affirmative defense of intervening and superseding cause. And while that might be a mouthful, it's really quite simple. Imagine that you wake up. You're early for work. You're driving down the road to your car, and when you get about a mile away from work, an accident happens right in front of you. The car is stopped, traffic comes to a halt, and you end up an hour late to work. Members of the jury, that's an unfortunate situation, and it's the exact definition of an intervening and superseding cause. And what it means in this case is that if there was something about the situation on August 18th, if there was something about the Parks home that wasn't safe enough, and that Hayden shouldn't have been expected to foresee, then you can't find him liable. We heard from one gun safety expert in this case, Dr. Ash DeRosa, and he told you what you have to do to properly store a gun. You have to keep it out of a child's reach. You have to keep the bullets separate from the gun itself. And you have to have a safe combination. But you heard today from Jesse Duran. You heard Jessie have to take that stand and recount the most tragic day of her life. And what did she tell you? She told you how two naive children were curious. How they went looking for a gun. How they went into an unlocked room, knelt down to an unlocked filing cabinet, and pulled out a combination to the Parks safe. A combination that was easy to find. For members of the jury, it was even easier to guess. Because that combination, Parks brothers. And with that combination in hand, they went to the Parks' unlocked bedroom. They went to a safe in the closet that was right at their level. They knelt down to it. They typed in that combination, pulled open the safe, and what did they find, members of the jury? A gun and a set of bullets, just begging to be loaded. In the course of today's trial, we've heard so much about what Jessie did wrong, how Jessie made mistakes, and she admitted that to make mistakes there as well. But as much as Mr. Nipper and the plaintiffs might want it to be so, Jessie isn't the one sitting in that chair. Jessie's not the one they've decided to charge. This is Mr. Hayden Burnett. He's not a monster, a villain, or a defendant. He's a responsible and loving father. And he's the one who should be with. In fact, he's the one the law demands. Because no matter how badly you think he might have parented, no matter how intentional you think that shooting might have been, when you go back into the deliberation room, the judge will instruct you that you have to ask yourself a few questions. If that gun had been stored separately from the bullets, could this have happened? If that safe had been out of the reach of the children, could this have happened? If on August 18, 2010, it was safe enough, could this have happened? And I'm confident the answer to all of those questions will be no. If you go back into the deliberation, if you remember the testimony presented and the evidence provided, and you come to that same conclusion, then you can only return one verdict: a verdict of not life. Because when it isn't safe and no one sees it coming, there can't be anything to prove.
Yeah, she doesn't have like.
Members of the jury, thank you for really telling you the story here today. You heard Jessie Durant herself take that stand and say that her father never punished her. Look at the evidence and find anything that's lying. Thank you.
I'm surprised they actually got something out.
Alright, good job, you guys. I wasn't going to torture you with comments because it's a lot of talk, but of course, yeah. So I typed them. If you guys want them, I can give them to you, or if you want to talk to me, that's fine. I'm going to be in a very long car ride with you guys, so I can share the car. Yeah.
Great job, guys. Good luck this weekend.
Excellent job.
You're gonna be killing them.
Yeah. Like your white charger? Yes. Oh, no, I didn't.
I cannot believe you actually got something out. I was like, yeah, I just want to get out for this. I'll be
Okay, so besides that,
That was really
let's take